This appeal is filed by me, the petitioner, against the order of the learned single judge. Last time it came up, we had agreed that it may be kept on another date. It's now kept today. And yesterday, after I had boarded the aircraft, I was told that they have filed an application to receive additional documents, and they have filed a reply affidavit to my stay petition. I'm not complaining about that. I'm only pointing out as a fact that yesterday they filed a reply affidavit to my stay petition in the writ appeal, and they filed an application to receive additional documents. Be that as it may. I'll tell you, Lordship, what the controversy is.
Do you wish to respond to the documents? And
I will. I wish to, and if your Lordships permit me, I will. But I have a proposal. I have a suggestion. I'll tell you, Lordship, please give me just 5 minutes for the clock. The controversy is about when a document was received in Madhya Pradesh for the purpose of stamping. Your Lordships know that a document executed outside the state of Madhya Pradesh is liable to stamping on the day it is, quote unquote, received in Madhya Pradesh by anyone, received in Madhya Pradesh. Now, in the writ petition, I propounded a date, 5/8/2019. Your Lordship may just kindly note these 3 dates. I propounded that this document was received in Madhya Pradesh. Well, this received has been interpreted in New Century Jute Mills, date on which it is received. I propounded 5/8/2019 as a date on which I submitted it to the stamp authority. In the counter and in the impugned order, the authority held that the date was 2/3/2017. 2/3/2017, the date on which the Allahabad NCLT passed an order and a scheme of amalgamation, which is the document sought to be registered. Now, this was the rival dates propounded by 2 sides. The state propounded 2/3/2017. The company propounded 5/8/2019. Now, whether 2/3/2017 is the impugned order and the state finally supported that impugned order, or whether the date I propounded will make a difference because of the notification. I'll come to all that later. The learned judge rejected both dates and then found that the date was 29/6/2017. My first ground is in certiorari jurisdiction, you can set aside an order of the authority if you find it to be wrong, but you can't substitute your view. But that's well settled, my lord. If necessary, I'll show authority. You can't find another date. You would have to remand it to the authority to take evidence and to hear both parties if both dates are rejected. Now, add to the further complication, yesterday's affidavit, they are propounding a 4th date, 29/3/2017. In between the date they originally propounded and the date found by the learned judge, 29/3/2017. Now, I can file a counter affidavit and we can argue it. But I think, my lord, I submit respectfully that the proper course is to remand it to the authority to decide which is the date. Because the section, your lordship may kindly have the stamp pad. Just one section of the stamp act. 3BB, section 3,
Of the
Clause B
Jabardast Stamp Act?
of the Indian Stamp Act as amended in
Well,
Madhya Pradesh.
yeah.
Well, the book contains the Madhya Pradesh amendments. Now, 3BB. Where's 3BB? It's not here. Does your lordship have the a later edition 2020 or so?
Yeah.
Now, if this is the same book, it will be in page 12 or so.
Section 3.
BB. Proviso BB. Section 3, ABC, then provided BB. Just to understand the section, please see Millet 3. Subject to the provisions of this Act and to the exemptions contained in Schedule 1, the following instrument shall be chargeable with duty of the amount indicated in that schedule as a proper duty thereof, respectively, that is to say, A, executed. Huh? My lord has the book.
Yes, we
Sir. Executed by any person is executed in India on after. B, every bill of exchange. C, every instrument other than a bill of exchange, provided that, except as otherwise expressly provided in this Act, and notwithstanding anything contained in Clause A, Clause B, or Clause C of this section or in Schedule 1, the amount indicated in Schedule 1A of this Act shall be the duty chargeable on the instruments mentioned in clauses AA and BB of this proviso as a proper duty thereof. So what applies is AA or BB. AA doesn't apply, Miller, BB. Every instrument mentioned in Schedule 1A as chargeable with duty under that schedule, which not having been previously executed by any person, is executed out of Madhya Pradesh on or after the commencement of the Central Provinces and Berar Indian Stamp Act 1939 and relates to any property situated or to any matter or thing done or to be done in Madhya Pradesh and is received in Madhya Pradesh. So it is AA is executed in Madhya Pradesh, BB is executed out of Madhya Pradesh and received in Madhya Pradesh. And Millard, a New Century jute mill case.
What is the document we are talking about?
This is the document, Millard, this was an amalgamation. Somebody was the owner of a number of cement plants. My company, my client, bought 2 cement plants. These cement plants are in Madhya Pradesh, Maharashtra, Uttar Pradesh, etc. I had to necessarily, my head office is in Bombay. Here's the seller's head office is in Allahabad. Therefore, we had to go to 2 company courts, which is the NCLT. So NCLT Bombay passed an order on a particular date, and I went to the stamp authority. That's not the issue. NCLT Allahabad passed an order on 2/3/2017. That is the first day, 2/3/2017. I brought the instrument and presented to the stamp authority, according to me. Of course, they are disputing it. 5/8/2019. So I'm saying it is received in Madhya Pradesh on 5/8/2019.
What was that instrument?
Amalgamation, scheme of amalgam.
So, if the order is passed on 2/3/2017,
Yes.
what could you draw?
Amla,
What did you present on 5/8/2019?
I'll tell you, Lordship. I had to go to various authorities to get the property mutated in my name, the mines transferred in my name, the factory license transferred in my name. It's a scheme of amalgamation, which is the basis of all these acts. I was doing it in Maharashtra, I was doing it in Uttar Pradesh. Then I came to Madhya Pradesh. Then I applied to the Madhya Pradesh authority. He said, produce the original document. I produced it on 5/8/2019.
What was that document? Only a certified copy approved
Yes,
by the
sir.
court.
Certified
An
copy.
order of the court.
Certified copy of the order of court.
So when was that certified copy issued?
Oh, it is issued, my lord, shortly after the Allahabad NCLT pronounced it on 2/3/2017. There was no difficulty in that.
Now, how do you say you received it in Madhya Pradesh?
No, I didn't. Authority received it in Madhya Pradesh on 5/8/2019. The stamp authority has, look, if your lordship sees New Century Jute Mills, it's very clear. If a document is acted upon in Madhya Pradesh, if any authority receives it, that is a relevant date.
No, is it authority received it or party received it?
No, authority
Is that
received
been
and
interpreted?
yeah, New Century Jute Mills is the case law on the subject. It very clearly analyzes and says if a document is executed outside a state, it is the date on which it is received in Madhya Pradesh which matters.
No, received by whom?
Received by the authority, my lord.
That's what
Obviously.
we want to know. Is it by the authority or is it by one of the parties?
No, the party is in Allahabad, my lord. Party is in Allahabad and Bombay. Company has various branches. I am in Bombay. I applied in NCLT Bombay and NCLT Allahabad, and I got 2 orders. Like 2 company courts. I got 2 orders. Then I have to do various things under the scheme to get the licenses transferred, the mines transferred, the mining permissions transferred, leases transferred. I'm doing all that. When I came to Madhya Pradesh, I informed the government that the secretary asked me to, the stamp authority asked me to produce the original document. I said there is no original as such, it's a certified copy of a court order. Then the learned judges found that in my favor, that a certified copy is the original. That I produced it before him in 5/8/2019 is not in dispute. What they are propounding is 5/8/2019 is not the first date. It is the date on which the Allahabad NCLT passed the order, which is relevant. The learned judges rejected that. The learned judges found that on 29/6/2017, I had applied for a mining transfer permission. That is, the mines in the name of the seller have to be transferred to me. And although there were no documents before the learned judge, from the correspondence, the learned judge said, since you acted upon the scheme of amalgamation and you applied for a mining transfer, I will take 29/6/2017 as a relevant date, which I say that is not the date on which the document was received. It was only a mining transfer for which I applied, the seller and the. Now they are producing a set of documents which apparently purport to show that this scheme of amalgamation was filed before the mining officer on 29/3/2017. That's what they filed yesterday, to which I have to file a reply and examine those documents. And I may even ask for
Then you file your response.
All I'm saying is, my primary argument is, in certiorari jurisdiction, your lordships do not substitute your view for the statutory authority and what is the relevant date.
No, Mr. Chidambaram,
Yes.
if we agree with you and hold that the third date.
Fourth date now.
No, fourth now, but the third date, because we are testing the order.
Yes.
Third date which has come in the order is not correct.
Yes.
We may still accept the date given by them or by you. So where's the question of remit? Remit is in case there is a confusion.
No, this is one of the points. The
Yeah.
learned judges remitted it anyway for calculation. Learned judges remitted it. for
Calculation of
further
deficiency.
calculation of various things.
Deficiency of
Various
stamp duty, that's a different issue.
Therefore,
But
I'm-
in Century Jute Mills,
I beg your pardon?
in the Century Jute Mills case,
Yes.
where is the finding that receipt means received by the authorities
Yes.
and not by the party?
Now, please see the judgment. Please see the judgment. Give a copy.
Sir, it's received in the state.
Huh?
Yes. So the copy there, so we've uploaded the copy in the system.
We have it. We have it.
We have it, right.
1964, 1 SCR 530,
Yes.
535.
16 to 20.
Now kindly see paragraph 16. It's a short judgment, my lord,
Yes.
but by a constitutional bench. 16. Some complications arise in the cases where both the liabilities arise. That is, where the instrument is executed in one state, but is related to property situated in or to things done or to be done in another state, and is received in the second state. In these cases, the liability to stamp duty arises first under the stamp law of the first state on account of execution of the state. A second liability arises under the law of the second state when the instrument is received in that second state. How is the liability to be discharged? Has it been discharged in accordance with the law in force in the state where execution takes place, or in accordance with the law in force in the state where the second dutiable event, namely the receipt in the second state, occurred? Obviously, an officer of the first state may reasonably think it is a law of his state which must prevail. And so even if the document is being stamped in accordance with the law of the other state, he may ignore that stamping as not done in accordance with the law in India and proceed to demand that it must bear stamps in accordance with the law of his state. It was to avoid the hardships that may conceivably result from such a situation that the legislatures of different states enacted Section 19 capital A of the Stamp Act. This section of the Uttar Pradesh Act runs as thus. Well, this is equal to our 3BB.
Yes.
See, where any instrument becomes chargeable in any part of the state other than Uttar Pradesh with duty under this act or under any other law for the time being in force in any part of the state, and thereafter becomes chargeable with a higher rate of duty in Uttar Pradesh under clause BB of the first proviso to section 3, which I read to your worship. Then, one, notwithstanding anything contained in the first proviso, the amount of duty chargeable on such instrument shall be the amount chargeable on it under Schedule 1A, less the amount of duty on it, if any, already paid in the states, in addition to the stamps, etc., that your lordship may know. Therefore, where the rate of duty in Uttar Pradesh, now substitute Madhya Pradesh for that, where the rate of duty in Madhya Pradesh for an instrument which becomes chargeable for stamp duty, as mentioned above, an instrument executed out of Madhya Pradesh and relating to property situated or to any matter or thing done or to be done in Madhya Pradesh with a higher rate of duty in Madhya Pradesh. Well, Madhya Pradesh has a higher rate of duty. That's how this issue arises. If the Madhya Pradesh was the same or lesser duty, this issue won't arise. To be paid in higher rate of duty in Madhya Pradesh than in West Bengal. Only the excess is to be paid in Madhya Pradesh, and it is only this excess which requires to be paid in Madhya Pradesh stamps. Section 19A in terms applies only to an instrument which, after becoming chargeable in any state outside Madhya Pradesh, becomes chargeable in Madhya Pradesh with a higher rate of duty. It seems to us, however, that where the rate of duty in Madhya Pradesh is the same or even lower, no further duty is payable on such an instrument. Or it would be anomalous and unreasonable to hold that the legislature intended that though where a higher rate is payable in Madhya Pradesh, the excess need only be paid. The Madhya Pradesh rate should be paid in full, where what was already being paid is the same or higher. The result of this will be that if an instrument, after becoming liable to duty in one state, on execution there becomes liable to duty also in another state, on receipt there, it must first be stamped in accordance with the law of the first state, and it will not require to be further stamped in accordance with the law of the second state when the rate of that second state is the same or lower. and where the rate of the second state is higher, it will be required to be stopped and only with the excess amount, and that in accordance with the law and the rules in force in the second state. The mortgage deed, which is a subject matter of the present petition, was executed in Uttar Pradesh, though it related to property situated in West Bengal and was received in that state for registration. The first dutiable event was the execution, which took place in UP. The second dutiable event was a receipt in West Bengal. When it came before the officers of Uttar Pradesh,
Oh, there's a full stop in between.
yes, full stop, brother. When
Yes,
it came
this is-
before I'm relying on that.
No, this is 3 stages. Execution, receipt, and present. And third is when it came before the officers for registration.
Let me read that paragraph
Yes.
again, brother.
Yes.
The mortgage deed, which is the subject matter of the present petition, was executed in Uttar Pradesh, though it related to property situated in West Bengal and was received in that state for registration. The first dutiable event was the execution, which took place in UP, semicolon. The second dutiable event was a receipt in West Bengal.
Now,
When
question
it
here,
came before, when it
Mr.
full stop.
Chidambaram,
Yes.
question is received by whom?
I think
Yes.
this answers it. When it came before the officers of Uttar Pradesh for decision whether it was duly stamped or not, the officers of Uttar Pradesh were bound to hold, for the reasons we have discussed earlier, that the instrument was not duly stamped as it did not bear Uttar Pradesh stamps. The fact that the instrument has been stamped in accordance with the law of West Bengal could not justify a conclusion it had been stamped in accordance with the law in force in India. The officers of the state of UP therefore rightly held that the original mortgage deed was not. It is a receipt by the officer in Uttar Pradesh. Well, this is a reverse case.
No,
This is the reverse case. I'll
Mr.
explain.
Chidambaram,
Yes.
here the document is executed in Uttar Pradesh,
But
But-
first of Bengal,
but not stamped.
not stamped.
In your case, document is
the other
executed in
way.
Uttar Pradesh
the
and
other way.
stamped.
Yes. No. Uttar Pradesh is pending, was pending at that time. Was
So,
pending.
question was whether receipt in West Bengal and stamped in West Bengal satisfies the requirement of being stamped in the state of
It
execution.
does not. It does not.
It does
If
not.
Uttar Pradesh is higher, it does not. If Uttar Pradesh is lower, it will. But here, although the document was executed in Uttar Pradesh and it related to property in West Bengal, for reasons known to that person, he got it stamped in West Bengal. He is entitled to. He is not required to stamp it in once. It has to be.
He has to pay higher of the duties. If he's paid it in the state which is higher, then nothing
Yeah.
needs to be paid.
The other duty, the other state will give a, well, he is entitled to, in fact, according to me, he is entitled to choose the state. which is
But pay
lower
the
duty.
pay the higher of the amount.
No, pay the lower of the amount first.
And then the deficit in the
Then
other.
the deficit in the highest.
Ultimately, duty is one, which is the higher of the two.
Correct, absolutely.
Either he
That
pays it
section
in,
says.
either he pays it
section
in two
says.
parts to a lower state and the deficit
It is
there. Or,
one state will get it or two states will get it.
Yeah.
That's all. In terms of my outgo, my liability is the same. Will I pay it in one state to the higher state, higher rate, the duty state, or will I split it between the lower duty state and the difference alone in the higher duty state?
but question is, what is the meaning of the expression received?
I'm answering.
Yes.
Here, what happened is, it was executed in Uttar Pradesh, property related to West Bengal. West Bengal was lower duty, obviously. So he took and he went to West Bengal and paid that duty. Then he came to Uttar Pradesh. Now, receipt in Uttar Pradesh, this third line. When it came before the officers of Uttar Pradesh,
That Don't connect it with the first sentence, just see the full sentence.
Yes, when it came before the officers of Uttar Pradesh for decision whether it was duly stamped or not, the officers of Uttar Pradesh were bound to hold that the instrument was not duly stamped as it did not bear Uttar Pradesh stamps. I had the document always, Miller. The person concerned had the document always. He took it to West Bengal first, then he brought it to Uttar Pradesh. When the date received in Uttar Pradesh is when the officer receives it from Uttar Pradesh.
That's not what this
It is always with me.
No. Mr. Chidambaram. Document is executed in Uttar Pradesh. You remain in Uttar Pradesh.
Yes.
Don't come to Madhya Pradesh. The day you land in Madhya Pradesh with the document.
Yeah, but in the example here in the Supreme
but
Court,
if
the
you look
document was always with him, whether when he went to Calcutta,
This may strictly not apply because the document was originally in Uttar Pradesh when executed.
Yes.
So received, it has to be the first state when it was executed in this case because it was executed in Uttar Pradesh.
No, but it was not received by an officer.
Can't be.
I executed the order.
But Mr. Chidambaram, what it further holds is the officer was bound to reject it.
Because
was
the West Bengal duty was lower.
No.
It says so, Miller. Stays so. Instruments was not duly stamped as it did not bear Uttar Pradesh stamps. The Uttar Pradesh can only be the deficit stamp duty.
It had to be, Mr. Chidambaram, this judgment may not strictly apply.
No. It's
For the
only for the
reason
proposition
proviso-
received. Only for the proposition received in the state.
Even then, you see, you are reading the word expression received in conjunction with the following sentence, the officer.
Miller, it is always with me.
So if
It was always with me.
this century case, the document was executed in Uttar Pradesh, then taken out and brought back.
Well, produced in West Bengal and brought
And then
produced
brought
in
back
Uttar
and presented to the officer.
That is the date which is relevant.
No, but in the proviso that you're reading deals
Yes.
with a case where a document is executed outside
Correct.
and for the first time is brought in the
Correct.
state.
That is our case.
Yes.
That is our case.
So this
My
receipt-
submission is to my Lord Chief, my Lord the Chief Justice's question. The document is in my hands always. Once the learned judge of NCLT Allahabad signed the document and I got a certified copy, the document is always with me. I produce it in Allahabad Authority on some day. Uttar Pradesh Authority, that was pending on that day. I produce it in Madhya Pradesh Authority on one day. The received in Madhya Pradesh cannot be in my hands in Madhya Pradesh. It has to be received in Madhya Pradesh. Received in Madhya Pradesh can only be by an authority in Madhya Pradesh.
Then it gives you an unlimited time.
It
You
does
never,
not.
never present it to the authorities, your time will not
If I
start
have
running.
nothing to do, if I have no compulsion to do anything in Madhya Pradesh, I don't have to present it.
But it is a document, you see, every document which is executed, if it is required to be stamped, has to be stamped within a
No,
particular.
only if it relates to property or to any matter or thing done or to be done in Madhya Pradesh. So if it relates to property in Madhya Pradesh, I have to, if the property has to be mutated in my name, I have to present it. To any matter or thing done or to be done in Madhya Pradesh. I can wait, my lord, when I have to do it. There's no compulsion that the document has to be executed, to be produced the next day. I can do it when it's necessary for me to do it. Business exigencies, my lord. When it's necessary for 3BB, very clear, and relates to any property situated or to any matter or thing done to be done in Madhya Pradesh and is received in Madhya Pradesh. Well, this received in Madhya Pradesh cannot be received in the hands of the person because it's always in the hands of the person. Received in Madhya Pradesh is some authority receives it in Madhya Pradesh. Any authority. I'm not saying necessarily stamp authority. That would be a very narrow interpretation. If I produce it before any authority in Madhya Pradesh, who is statutorily exercising something which I have to be done or to be done, that is a document. If he is not the stamp authority, what he will do, Miller? He will impound the document and refer it to the stamp authority. If he is the stamp authority, he will stamp it. Therefore, received can only be received in Madhya Pradesh, received by a governmental authority in Madhya Pradesh. Miller, I can give it to my manager. That is not received in Madhya Pradesh. It is received in Madhya Pradesh only for the purpose of stamp duty.
Even impounding says so.
Even impounding section 33 of the Stamp Act, which is what I just now said. Kindly see 33.
Then 33 becomes OTO.
No.
Because there can never be an impounding.
No, 33 becomes relevant. Please read 33. Every person having by law or consent of parties authority to receive evidence, and every person in charge of a public office before whom any instrument chargeable in his opinion with duty is produced or comes in the performance of his functions shall, if it appears to him that such instrument is not duly stamped, impound the same. Once he impounds it, he refers to the collector. Now, this is according to me, consistent with the day-to-day practice. I take it to various authorities if it's a nationwide operation. I don't have to take it to all the authorities on the same day. When I have to get something done or to be done, I take it to an authority. If it is not stamped and if he thinks it's stamped, he will impound it under 33 and refer it. Now, in this case, they have now yesterday, according to them, got documents which was not before the learned single judge, not before the court, not before the impugned order authority. They have come across documents which, according to them, points out that the document was produced before an authority on 29/3/2017. That is the fourth date they are propounding. 2 dates we propounded. Learned judge found a date, third date. They may be right, they may be wrong. I'm not willing to state anything unless I take instructions to my client. The fourth date they are propounding. Now, which of the dates I submit, Miller, with great respect. I think I'm a good legal authority to support that. In certiorari jurisdiction, your lordship will not fix the date. You send it back to the authority, point out the controversy, and say you decide according to law and the evidence. Anyway, the matter is remanded.
No, Mr. Chidambaram, let's test the counter filed by them.
Yeah,
They're saying you presented it before an authority on.
that's what they said.
Now, assuming you also accept that, yes,
I have
that
not
was,
taken instructions.
that's why I said, assuming you also, your instructing counsel takes instruction and instructs, yes, that was the day we presented it first.
Yes.
Then where's the question of sending it to an authority to assess what was the date if you accept it? If you accept it as the trigger date, then the calculation will take place, even in these 2 to 6 proceedings.
The question is, did I present those documents to an officer?
So take instruction on that. If you have, then at least that part of the controversy.
Presented that document to an officer, because what they have filed is, they may have another document, I don't know. What they have filed is the 2-page order of the judge, but the scheme has not been filed in the compilation. Now, what is the implication of that? I will take instructions and your lordship will finally find. The scheme of amalgamation runs to 400 odd pages. The instrument is the scheme of amalgamation. They have filed a 2-page order of the NCLT Allahabad. They have not filed the 400 odd pages of scheme of amalgamation. Whether it was there in the file or not, I don't know. I may request the learned advocate general give me inspection of the file. subject to your lordship's orders.
Now, if you see page 9 of their list of documents,
Yes. They are
serial number 2.
now, the new document, Miller?
Yes.
The new document.
Page
Yes.
9, the serial
Yes.
number 2.
Yes. Yes.
It says list of certified copy of NCL.
Document was received in Madhya Pradesh should also be remarked. That is what I'm saying. But if your lordship thinks otherwise, I will come back, file a reply and inspect the file and then make my submission.
My lord, what I respectfully submit. My lord, we have moved an application raising objection with regard to maintainability of this writ appeal. My lord, my learned friend has not addressed on that application. No reply is filed to that. And now, my lord, your lordship,
Why is
we
it
raised
the,
objection with
why
regard
is
to
the writ appeal
maintainability of
not
this writ
maintainable?
appeal. The copy well in time was applied to the other
Why
side.
is the writ appeal not maintainable?
My lord, we have come out with a case that, my lord, the collector stamp has adjudicated the issue
No, this is an order. What is being tested here is an order passed in a writ petition under 226.
under Article 227. This is what our humble submission is.
That 226.
So, my lord, we raised that objection, but you,
Well, the learned judge by a separate
what
order,
I'm
judged by a separate
that's
order,
fine.
held
What your
this was
lordship-
under 226 and the objection was not maintainable.
okay, but you need to address on
I
that issue.
understand.
Your lordship may kindly appreciate, my lord, there is an objection on behalf of the state.
If the learned single judge has held a writ petition under 226 to be maintainable,
Yes.
and you are not aggrieved by that order, you're not assailing that.
They have
order.
not appealed it. They have not appealed that order.
No, my lord, not in the order which is impugned in this writ appeal. It
Even
is not
earlier,
held.
Earlier order.
if
That's fine.
you've not impugned it, so why should we now reopen that issue?
Your lordship may kindly appreciate what has happened, my lord. Against the order of collector, there was a first appeal maintainable before divisional commissioner, and second appeal is provided before board of revenue. So at the initial stage, my lord, when this writ petition came up for consideration before learned single judge, we raised this objection, my lord, that it is the order which is assailed in the writ petition is appealable. So, my lord, that objection was turned down. And honorable single judge was kind enough to proceed further with the writ petition, my lord, dealing on the merits of the order.
Rejection of that order is not challenged by you.
25th November.
No, that we have not challenged by.
I have the order.
That's all
No,
right.
it's okay. So
25th
now,
November
now your lordship may kindly appreciate.
You are 25th November 20.
I think-
Both
My
objections
lord,
were raised. Both objections were raised. Rejected.
He is conceding that that has not been taken up.
Very well.
So, Mr. Singh, the only issue is in case they admit that the date which you say is in your return as the date when it was first presented along with the scheme of amalgamation, then at least that aspect will be closed. The rest, the learned, so when should we have it?
Millard,
And my lord, since 2020, my lord, they have not paid anything.
We'll
So-
finish it just now, Mr.
Yes.
Singh. In a week, it will be over. It's not.
Millard, I will request the learned advocate general to give me inspection of the file. I'll
Find out, probably your clients would confirm, his clients will confirm it is there.
No, I want to see what was, because this is filed by the transferor, not me. Transferor is Jay Prakash. Therefore, he kindly see list of documents from transferor. If it was me, Millard, I would not answer. List of documents from the transferee is only sir is entitled to inspect the file.
Your lordship may kindly appreciate, my lord, in the return before the learned single judge, we took a specific stand. My lord, that the 4 mining lease, they got executed at the instance of the petitioner, and that was the date when, my lord, the instrument was first presented in the state of Madhya Pradesh. Now, my lord, there is no rebuttal to that government. Now, my lord, before the honorable division bench, my lord, we have simply filed those documents so that the honorable court may have an opportunity to peruse those instruments, my lord, those documents. So we presented it, my lord, and so as to avoid bulk of this IA, we have filed only, my lord, the extract of these deeds, my lord, that we have filed. So my respectful submission is, my lord, if they want to file reply to this IA, my lord, they may file it. But before the learned single judge, my lord, their case was that they filed some representation.
Look at the case law. Now, my learned advocate general
We will ask you.
Has filed an affidavit. Now,
Yeah.
please see paragraph 6 of the affidavit. Paragraph 6 of the affidavit. Therefore, it is not as though I'm straight away liable to pay 25 crore. 25
We
crore,
are flagging a concern.
yes.
Supposing you have assets in Maharashtra.
I've understood your lordship.
Uttar Pradesh,
That is 32 crore, this is 25 crore on different assets, you have to pay it separately.
Yeah.
That is not my humble interpretation of the section. The section says if the instrument has attracted stamp duty at a higher rate, if the Supreme Court New Century also.
My lord, we have levied, your lordship may
1670
kindly
matter with-
appreciate, we have levied stamp duties only on the movable and immovable properties in the state of Madhya Pradesh.
That is
No,
what
no,
Mr.
but-
Dabra is submitting, that if I have paid stamp duty in any one state.
Yes.
For the assets there, I am exempted from stamp duty.
No, this is something,
That's his argument.
sir,
You have to
ek consent, your lordship, this, what my learned friend is doing, my lord. My lord, absolutely a new case is trying, my lord, he is trying to place before your lordship, which was not the situation before the learned single judge.
see,
My lord, 2-3 lines, my lord, I may be.
He is raising that issue, we'll have to deal with it.
Yes.
We may accept your argument, reject it outright, but we'll still have to deal with it.
But my lord, how they can come out of the, my lord, the consent which they gave.
Dabra will show
No,
how-
your lordship may kindly permit me to read 3 lines, my lord.
Yeah.
This is the consent which they gave before the learned single judge. They cannot run away from the consent which they gave.
Consent.
My lord, may kindly come to para 17, page 60. Okay.
The first letter that I wrote.
My lord, may kindly see what this.
Before that, I'll argue. Unless your lordship lays down the law, which is the notification, what is the meaning of section 4.2? There are a number of issues, my lord. What do I say in response? And then they will say you conceded this, you conceded that. What do I say in the response to the show cause notice? He is now obliged to issue a complete show cause notice.
So let him,
The
in
learned
any
single-
case, by the time he gives you a show cause notice and time to respond, we would have concluded. these
Let him
matters.
issue a show cause notice. I have no problem. But I won't reply, but I'll take that.
My lord, your lordship may kindly see, my lord, only on the limited issue, my lord, the matter has been remanded. Now, your lordship may kindly appreciate. Here, my lord, they have not paid a single penny. There, my lord, they have repeatedly made this.
Who is competition, let him compute, it will be.
So, my lord, we may be allowed to proceed further as directed by the learned single judge.
Compute it, it will be subject to further orders passed by the.
Bilkul. I'm so ideal.
Paragraph 87 of the learned single judge said, you will appear before the collector on 26th August, which was understanding was I won't appear. And the collector of stamps shall decide the matter within a period of 1 month. I'm saying, let him issue a show cause notice. I can't stop that. Let him, on the basis of this judgment, let him issue whatever show cause notice. I will take time to reply and I will appear before your lordship on October.
Show cause is not required. What will issue show cause?
In the meantime, any decision taken by the collector pursuant to the order dated 12/8/2024 impugn hearings shall be subject to further.
Yes.
To do an assessment.
Yes.
Let him assess. He
Yes.
will not implement it without leave of this
Yes,
court.
yes.
He
But,
will be,
what-
Mr. Chidambaram, assuming we were to reject your appeal.
Yes. He will issue a note. I'll appear before him the next day. Your lordship will fix the
Only
date.
thing is that 1 month period that is there between now and the next date for us to decide this appeal. If he's done an assessment, we'll.
No, no,
uphold it.
I have no objection to his issuing a show cause notice.
Mr. Chidambaram, this 1 month period, if he doesn't, assuming we uphold your objection
Yes,
and set aside the order, then whatever he's done, we'll have to redo it.
absolutely.
If we reject your.
Yes, it may be heard finally, or else it may be heard finally on that day.
We are listing the appeal for final disclosure.
Yes.
ठीक है साहब.
16th October.
ठीक, ठीक.
Appeal will be heard on 16th.
16th October.
जी,
16th
बिल्कुल.
final hearing.
Obliged.
And
I'm so ideal.
Mr. Chidambaram has suggested if we don't conclude on 16th, we'll continue on 17th and conclude.
ठीक, ठीक.
Obliged.
I'm sorry.
Number 13, number 500,